Good afternoon, and thank you for joining us. I'm Robert Baylor, Director of Communications at NUCA. Welcome to our latest webinar. First, before we begin, some webinar housekeeping for attendees. Today's webinar will be recorded. It will be available in the next few days on NUCA's YouTube channel and our webinar webpage, both of which can be accessed via NUCA.com. Now about your WebEx Meetings webinar screen. There are two buttons on the lower right-hand side of your screen titled Participants and Chat. Clicking on Participants gives you a list of webinar attendees. You can chat amongst each other, or you can send the host questions or messages. All participants are muted upon entry. Phone participants can use *6 to mute and unmute themselves. Questions will be asked at the end of the presentation. To ask a question, you could submit a written question at any time using the chat feature, and I will read them at the conclusion of this discussion. We're also going to ask you to help us with a few survey questions via your smartphone. I'll have this information written in the chat, but if you text to 22333, the message Cohen Seglias 527, you'll be set to answer our questions later in the webinar. That's to 22333, the message COHEN SEGLIAS 527. Again, I'll write that text information in the chat, and Shawn will have it in his presentation as well too. Now let's get started. We've all been faced with the reality that material shortages and challenges and high costs are likely here to stay for the near foreseeable future. These unexpected additional costs are wreaking havoc on existing and pending projects. The government and Congress can only do so much in the short term, but what can NUCA members do today? NUCA has been your resource for a number of webinars and white papers on this important topic, all available on NUCA.com. Today's webinar will discuss how contractors can mitigate the risk associated with today's unprecedented material cost increases. Joining us today are two industry legal experts, Thomas Olson, Esquire, of Olson Construction Law, and Shawn Farrell, Esquire, of Cohen Seglias in Philadelphia, Pennsylvania. Both are counsel for the NUCA chapters in their states and will share their strategies for you to implement a best practices methodology for this ever-changing supply environment. Thank you all for joining us today on this special NUCA Webinar Wednesday. Gentlemen, I turn the webinar over to you.
Thanks, Bob.
Ready for me?
I am. Yeah. I think that was a great introduction. Thanks, Bob. I really appreciate it. We have a lot to go over here today and little time to do it. So I think when Tom and I were talking about how we could present this, I think we kind of concurred that we're going to be issue spotting. We're going to be giving you a lot of information. This whole presentation will be available through NUCA and their website, so you can grab it and get it as far as notes are concerned. And then, follow up as you need to when and if you face these issues that we're going to be talking about today. So with that, I'm going to turn it over to Tom, and we're just going to try to play a good game of tennis here, hitting the ball back and forth, going through these various issues that we think are important for the industry to coalesce on and get to agreement on how we're going to try to collectively tackle these issues. So Tom?
Right on. When I click forward here.
Yeah, there we go.
Right on. So I've always been saying, or certainly for years to contractors, there's three things we can count on: death, taxes, and late utility relocation / unmarked, mismarked utilities. I guess we're going to have to add one more item to that list. Next, supply cost increases, delays, and in some circumstances, unavailability. And certainly the problem with supply-related problems are something that's going to continue throughout this year and unfortunately probably beyond that.
Yeah, and to that, and this is what Bob was talking about at the opening. We're going to try this out. I don't know if it's going to work or not, but we're going to try it. If not, we'll adapt and we'll move on. But if everyone who's participating in this seminar can text to 22333 the words Cohen Seglias 527, what that's going to do is that's going to allow you to enter into a free online sort of polling questionnaire session. So I'm going to put the questions up on the screen here, and then we're going to ask you guys to respond either by hitting an A or B or C and enter on your phone, and that way, we can start to have a better appreciation of of how we're all collectively looking at this, because I think, Tom and I would agree that, one of the powers of NUCA is not only its ability to get legislation passed and to promote our industry, but to share what's happened to each of us individually so that we can all have a lessons learned without having to actually live the bad occurrence. Because, I often tell clients, listen, the first time you get into a piece of litigation, you never look at a contract the same. You never look at, a litigation the same as you did when it was just all about a movie. So with that said, the first thing that I was hoping that we could do to kind of test this polling thing out was to figure out who's kind of on the line. And this will give us sort of an idea if you're a prime contractor or a subcontractor or a vendor. Let's just start to vote. I can see the votes are coming in. So I'll just give this a second, because obviously what we want to do is, we can gear this towards all of these sectors of what you should be doing as a subcontractor, as a general contractor, as a vendor. And it's a little different, to be honest with you. How you approach this and what your goals are to achieve from this are going to be a little bit different. It's whether or not you're talking to a general contractor or you're talking to, an owner. So, all right. We've got about 50% of prime contractors and about even split then the next 50% between subcontractors and vendors. That gives us a good approximation of who's on the phone. So that's always nice for us to understand. So with that understanding, let's talk about this question. And this question is, who bears the cost of material price increases? Would you think that it would be the owner, the prime contractor, the subcontractor, or the material supplier? Well, no one thinks it's the material supplier, Tom. This is going to be a shocking seminar when we tell you the answer.
Well, I think the conclusion is a material supplier is best suited by its bid to protect itself.
Yeah. All right. Well, as the answers kind of come in, let me give you what I think the answer is. And the answer is, this is a trick question by a lawyer, because there is no one size fits all that always the owner or always the prime or always the subcontractor. These are very factually nuanced situations that you have to understand what party is responsible for this business risk of material prices going up and down. And quite frankly, a lot of it is going to be driven by the contract itself. So what we want to do is, make sure that we have an understanding of where we sit in the chain and what pressure points we have or legal authority we have to demand increases in price. Okay. So let me see if I can move to the next slide. Move too far.
There we go.
This is you.
So what's amazing is to look at the statistics as one measure of the exact scope of how problematic the issue is that we're talking about today. Look, if you look at the first part, supply disruptions were up 638% in the first half of 2021. It's amazing. Another way to measure it is to note that of AGC members that were surveyed on this, 88% of them said they were experiencing delays on projects, and 75% of that was attributed to a material related problems, which is to say longer lead time to get the material. Okay. Next, Shawn.
Yep.
Okay. So the issue of material related problems in terms of the time to get it and the cost to get it is huge. It's not going anywhere, certainly for the foreseeable future. So insofar as we can't change the underlying problem, which is to say to get rid of it, what there is to do is how do we manage it? How do we manage it in a way that that there's adequate protections that are equitably made with regard to the owner as well as generals, subs, and suppliers?
Oh, hold on.
You can go next.
Next.
Yep.
Okay. So as of today's date, I'd like to know how many people out there have approached an owner or a prime contractor requesting additional money for material costs or labor increases because of COVID or because of supply chains on a lump sum contract. Wow, that's fantastic. So I'm glad to see that it looks like the majority of the people responding have said yes to this question. I see a couple of no's coming in because, quite frankly, every contract is different, and every contract has the potential opportunity to provide you with the relief that you need. So we're going to walk through and hopefully give you some tools today to think about and to educate not only owners but yourself on what should I be doing at each step and each stage of this contracting issue and material price increase to maximize the possibility that you guys are going to get paid out there. So with that said, let me turn it over on and let's talk about pre-bid phase and what we should be doing in the pre-bid phase.
And to follow up on Shawn's point in the last question he asked, which is so important, which is, are you asking for financial relief as well as potentially a time related extension? And I like to say, the girl can't say yes unless you ask. The worst thing she's going to say is no. And that's my personal as well as my business philosophy. So, as a starting point, we need to exercise that ability to ask for it. And certainly the first place to look to ask for it is a pre-bid phase. The ideal is to get a price escalation clause, material escalation clause included in the contract if there isn't one. And by way of a price escalation clause that provides that to the extent that there are increases that occur post-bid, post-contract, that a contractor has a right to get dollars related to that as well as time. The opportunity at the pre-bid phase is to approach the owner to ask for it, whether it be by way of a formal pre-bid conference is scheduled, or if one's not formally scheduled, to actually ask for one. And insofar as the issue that we're talking about today is driven by the material increases that start with the supplier, we really encourage you as part of that meeting, be it in person or phone, to actually include the material suppliers whose product is at issue. It's a lot easier to have that supplier to be able to tell the story, as well as that it's not just a local issue, but it's a national issue, as well as yourself. So we think it'll be more compelling if, when you ask for inclusion of a material escalation clause at the pre-bid phase, to make that request supported by somebody from who's supplying the material that's at issue.
Right. So here's an example of a material escalation clause. And we urge you to take this as an example and to use it because it really satisfies what you need to do to put everyone on alert that you're going to ask for additional money, right? So you're giving the construction, you're giving this proposal out, and you got to make sure that you're attaching to this proposal the reasons that you think you're going to be coming back potentially asking for additional money. Now, it could be COVID. This one is particular to COVID-19, but whatever the unforeseen occurrence is, if it's a supply chain issue and you're starting to feel that, you've got to have out there that, listen, if this happens to me, I'm going to be coming back and I'm going to be asking for additional money. This puts them on notice. It'll satisfy your contract issues of that. If it's in your proposal, and we recommend it as drafted here, if it's in your proposal, make sure it finds its way to the contract itself. Okay, you can put in the proposal that's automatically going to be incorporated in, but most courts won't accept that. So include it as an exhibit, copy paste the language, or on the next clause, here's a material escalation clause for a contract. You can use this type of form in your contract itself. It says, In the event of significant delays or price increases in material, equipment, or energy occurring during the performance of the contract through no fault of the construction manager, replace prime contractor, subcontractor, whomever you are in that chain, the contract sometime of completion or contract requirements shall be equitably adjusted. And then this last sentence is an important one because no one likes to feel like they're getting taken advantage of. Like there's a shell game that they don't understand it and you're just trying to, correct for a bid bust. It says a change in the price of an item of material, equipment, or energy will be considered significant when the price of an item increases by blank percentage between the date of the contract and the date of installation. Now, whatever that percentage is up for negotiation. Certainly you can suggest something. I think, when we're talking about federal, contracts, material price increases that go off, 20% of the estimated quantity are allowed to be negotiated at a different unit price. So that might be a starting ground for everybody to understand that we can have these increases. But this is the kind of thing that you want to have in your contract. But just because you have it in your contract, it doesn't end there. Just because you have a material escalation clause in your contract doesn't mean that, okay, I automatically get it. You still have to make sure that all the other contract requirements are followed. There is a case with the Civilian Board of Contract Appeals. It was Pernix, and it was related to the Ebola virus. Now, this was a federal job, and Ebola was breaking out in other countries. And in Sierra Leone, where this contractor was working, eventually the World Health Organization said, everyone's got to go home. But not the contracting officer. The contracting officer never made a determination that it was time to go home, stop the project. He left it up to the general contractor. And so the general contractor followed the World Health Organization and eventually let everyone go. And when everyone came back, he was looking for time and he was looking for additional money for material and labor, and it was denied. And it was denied because it was deemed to be a unilateral decision. It wasn't a decision that the government, the owner in this case, participated in. So there's a lessons learned right there. They had the federal acquisition regulations control all federal jobs. So they had material escalation clauses that would allow for an increase due to pandemics. They, again, were denied. We should learn from that to say, listen, just because I have a material escalation clause in the contract doesn't mean that I'm not going to follow the other rules and regulations that Shawn and Tom are going to give you here today to document, to put people on notice, and to show some transparency on how these increases have been imposed upon you outside of your control, all right? But the best starting ground for predictability, in my estimation, and clients ask me all the time, well, if I sue someone for this or that, am I going to win? And I always say, well, what's your contract say? If your contract is clear enough, you've got no problems. It's when it's ambiguous or doesn't address a situation, that's when it becomes factually in dispute. And then, it's a whole different game. But predictability is based upon the contract being done right up front. So we got to focus more on the contracts. Let's start with the education in the pre-bid. Let's ask for these clauses. Okay. Tom, this one's you.
Yeah. So again, we're at the pre-bid phase, and this is focused on what we can ask of the owner for purposes of trying to protect yourself. And, certainly the first one and most ideal or potentially would be asking for material escalation clause to be included in the contract. There's some other important measures that you can ask for. Second one here is request that the owner purchase the material rather than having it be provided as part of the contractor's bid. And what's interesting about that is, in preparation for this, I was looking to collect information with regard to what was happening elsewhere. And I got a hold of just yesterday a memo that the South Dakota DOT sent out to not only to its staff, but also to Federal Highway. And I noted, and by the way, for this, what I'm going to talk about, I'd be happy to make this available to folks, and we'll figure out how to do that. But the last item on there that the DOT in South Dakota was recommending was pre-purchase of materials. So what's important to get is that, the owners are educated, at least to some extent of this, probably more so with DOTs than they potentially are in city county levels of government. But, here the DOT in South Dakota is taking the lead in recommending to its staff that the DOT look at pre-purchasing the materials. And it's a way to, put the cost properly on the owner and eliminate the risk associated with not only the cost going up later, but also potentially mitigating against delay, because if the owner's already purchased it, we eliminate the delay of or potential problem of trying to get it later on in the project. Another means to do it is to request that that portion of the work be done on a cost plus basis. So just have that item by way of special supplemental condition priced differently that otherwise would be done if it's a unit price job. And certainly another one is if there's other materials that could be used for it. So let's say the problem is the shortage is related to PVC as opposed to potentially ductile iron. To recommend the owner use a pipe that's more readily available, as well as potentially at a price that's more stable. And again, I think what's important to understand about that is I've got, let me just pull this. I've got both the DOT in South Dakota recommending that, as well as the DOT in Texas. And both of them were saying, the South Dakota DOT was saying, when material availability will delay work and completion of the project, the department will consider proposals from contractors to substitute materials.
And everyone should understand, if I can jump in, Tom, that what Tom just told you is so important, because if you're sitting in New Jersey or Pennsylvania, I'll use that information with the DOT here as well. Hey, Texas is allowing this. South Dakota is allowing this. Why won't you allow this? It gives that confirmation bias of if everybody's doing it, it's good for you as well. So, that is really valuable information Tom just gave us, and we should all collectively be using that to our advantage. Sorry to interrupt, Tom. Go ahead.
No, that's fine. And I'll make sure I get both of these memos, because it's going to make your job easier in making requests like this, to the extent that you have, emails that were issued by the Texas DOT as well as the South Dakota DOT. It's like, hey, look at, what I'm proposing is indeed what, other DOTs have already themselves proposed, and recognizing the scope of the problem. A last one that I just wanted to offer in this is to, part of what I see is the problem for contractors, be the generals or subs, is they're getting a quote from the supplier that's limited so much by time that by the point of the bid letting, the effective date of that supply quote has already expired. So one way to potentially mitigate against that is to see about having a shorter time frame for the bid phase of the project, as well as potentially the contract award.
Okay. Tom, this is Bob. Send me the two memos. I'll put them up on NUCA.com.
Okay, I'll do that. Just
before I move to the next slide, also make sure, just because the owners are willing to purchase the material, make sure he's willing to pay for storage as well, if you've got to do that. So think through the issues of where you're going to put that and who's going to protect it and at whose cost. Next slide, Tom.
Yeah, actually, before I move on, I'll go back 1 second. I want to say one last more thing about it, which is it's we're giving some specific examples, but really the opportunity that we really encourage is to think out of the box. And and in that regard, I found it interesting. The last item in the South Dakota DOT's memo that was issued in March, when they were polling or actually educating the DOT engineers throughout the state, they said to look at other innovative approaches to minimize the impacts. So, here we've got a DOT that's giving some specific examples, but also recognizes the problem is vast enough that it's willing to be pragmatic and look at other approaches. So again, share that. And I would also offer, if and to the extent that you have success in your state, county, city, DOT projects, please share that with members in order that we can start to build the momentum in support of, for the next time that one of the members goes to request at the pre-bid phase, one of these remedies or other ones, that you've got more support for it. Hey, we're just asking you to do what they've done elsewhere.
Okay. Yeah.
Next.
All right.
So certainly on a public job, generals and subs can't qualify their bid. I mean, I guess you could as a sub, but if I'm the general, I wouldn't accept your bid. I mean, if it's conditioned upon only, being awarded in a date that doesn't align with, the date for me as a general is going to get the contract, I think it's probably going to be rejected. Certainly as a general, you can't qualify your bid on a public project to the owner. But certainly on a private job, since it's not subject to the public bidding laws, you have the right to qualify your bid, be it as a general or a sub, to say, hey, look at, here are the conditions of my bid. And certainly you can have whatever ones that you have in there consistent with some recommendations that we're making. But again, while a supplier on a public job can qualify their bids, which is to say my bid's only going to be effective for this period of time, since generals and subs probably won't be able to do it in public, what we're proposing here is something you'd be looking to do in a private job. Okay, next. Shifting from the pre-bid to the bid phase. The first one is something that, I say you can include a contingency in your bid. Of course, the real world is, it's not so effective, because if you're including a contingency bid, chances are not everybody else is going to, so you're not going to be low. So while you can do that, if you're full with work, maybe you've got the ability to do that. The effectiveness of this is probably tied, certainly in public work, to the extent that other bidders are approaching it the same way. If they're not, insofar as work awarded normally on the basis of low for public construction, that's certainly going to, while it's going to protect you, it's also going to keep you from getting the job. Another recommendation at the bid phase is, if you can and have the financial ability, purchase and stockpile the materials. In other words, if the nature of the work that you're doing is such that, you're going to be using those materials, whether it be on the pending project or future projects, lock it up, stockpile it now, put it in the yard if you can. Way to both control costs as well as minimize problems associated with trying to obtain the material. And the last one is, purchase and stockpile of material for projects not yet awarded. Again, if you have the space in your yard as well as the financial resources to do it. Again, all of this is, how do we approach the same thing differently to get a different result? So we're looking at pragmatic ways to proceed. Okay, next one. So here's a project awarded, but not under contract. And again, some of this is redundant, but again, to recognize that what makes sense at a pre-bid phase as well as a bid phase can also make just as much sense after the project's been awarded, but not under contract. Okay, the first one is, again, request that the owner use alternative pipe materials that might be either more available or otherwise not subject to the same sort of price instability. Second one is, request the owner delay the work performance. And in fact, when I was looking at that one, I noted that the Texas DOT, and this is a memo that they wrote last month, themselves recognize that as an appropriate means to proceed. Utilize delayed start provisions as necessary for contracts that require materials that are experiencing availability issues. So again, what's nice about that too is we have, a recommendation from the DOT. So to the extent that you're looking to make that or other recommendations, you've got the support of what's already being recognized elsewhere as being suitable. Certainly sort of one that I would say of last resort is, if you don't have suitable protections in the contract, be it you've tried and failed, or otherwise, you're left with, a contract where, you're on the hook to pay the price increases. One thing you might want to evaluate is, okay, if the cost increase is potentially so large, you might want to examine the cost of not signing the contract. Certainly the owner would have the right to make a claim under your bid bond if you're the general, but again, you might have to evaluate is a more cost-effective way to proceed rather than proceeding with the contract and having potentially to bear a huge amount of dollars that aren't included in your bid. That's going to be the basis of your contract with the owner. Okay. Let's shift to the build phase. You got the contract and you're proceeding. And again, whether you've tried or failed to ask for it earlier, again, it's no less appropriate to ask again, or for the first time, hey, look, if there are other materials that are available, other, we're talking about pipe here, of other pipe that's available more readily, and or the pipe, another pipe isn't subject to the same sort of price increases, request the owner substitute it. And again, I gave you an example earlier where the DOT has recognized that. Secondly, again, request the owner delay the work performance to a time that's more suitable. 2 or 3, exercise contract remedies, which circles back to what Shawn says is so often when we're approached with an issue, one of the first questions that we ask is, what does the contract say? And too often, while the contractors are good at evaluating the technical specifications of the contract when bidding, as well as the plans, what they're not as focused on is the general conditions portion of the project. And it's just critical to be evaluating that in terms of what rights do I have relative to this issue. The fourth option is a really good one, which is even if you don't have express contract remedies provided in the contract, that shouldn't stop you from asking the owner nonetheless for help on it. I had a project not that long ago with the city of Fargo where there was not a provision for dollars, only a provision for time. The issue was the increased cost of pipe. And working behind the scenes, we set up a meeting with the city, with the general, the sub. And although the city was not under obligation to pay for it, they ended up agreeing to pay a third of it. Sort of again, the girl can't say yes unless she asks for it. And I think what's also important, that was an example of where that worked. I noted when I was reading through this Texas DOT memo that was just issued last month, one of the recommendations it had, in fact, the last one was, if none of the above options are possible, price increases can be referred to TxDOT administration for further consideration, which is to say, the DOT, even on a DOT level, they're recognizing that even if we don't have an obligation to pay for dollars related to this problem, that's not to say that we won't.
Yeah.
So
I was going to add in there, Tom, that I've found that every private owner, it seems, is willing to negotiate this almost despite the contract value, because they realize that a contractor going out of business is going to be bad for their bottom line on that very project. To find a new replacement contractor to come in and pick up the schedule is going to be very difficult. And I think that's the driving force, even with the DOTs around me and obviously around you, Tom, is that the owners are willing to talk about this when they realize that you're not making up for a failed bid. If it's a bid bust and they have reason to believe, I mean, listen, if you were, a $500,000 low on $1 million contract, you might have some hard times with a public owner negotiating. But if you're transparent about it and asking for something, as Tom said, that's equitable, definitely ask. Which leads to the next slide here about change orders. Because what I want to tell you about change orders, when we all know what a change order is, but change orders can change the terms of your contract as well. It's not just, I want this money and this time. A change order, legally speaking, is just a rider or an amendment to the contract. I had a client once where he was following the notice provisions in his contract and putting the owner on notice through the construction manager every time there was an issue. And eventually he was called out in a meeting and it was said he's trying to be litigious. He's trying to set people up for a claim. So I had him do a $0 change order that just took out from the contract any notice provisions of a claim. We'll just work it out in the old-fashioned way at the end of the job. Now, as you can imagine, and as Tom would guess if I asked him, no one signed that change order. They like the notice provisions. They know that they protect the owner, and no one's waiving that. And the idea that he was being litigious when he followed their notice provision was just a means of what I would say is bullying the general contractor into not following his own contract. So we have a gotcha moment at the end, and then you're just really relying upon the equity and good graces of the owner to give you a change, as opposed to you followed your contract. So think about that in this context. We can put into the change order that this change order does not include all my costs, because I don't know what the costs are yet. They may fluctuate when I go back if you're ordering things out of time, or include it would even be better into the change order. But if you can't protect yourself and say, as this term in this slide says, which is these costs shall be included as soon as quantifiable by the contractor, that in your change order protects you. Now, if you could actually change the terms of the contract in general, that would be great too. But at least we're mitigating risk when we say, okay, I've got some change orders. They're big change orders, and I can't cost it out. You don't want anyone to come back and say, you're not entitled to any more money because I gave you a change order and you had the opportunity to price it before I signed it. So if you can't put in a fully loaded change order, think about putting in this language. And then that is also a good recipe to the actions of people and acceptance of this. If you got acceptance of this on a few change orders, did impact your contract and did open the door to a modification of that overall, where you might be able to come back in a more global sense and look for additional money. So I guess the sum and substance of my recommendation here is look for the opportunities. When you know you're on a project and you know the prices are increasing, even when you have a bad contract, even if you don't have a material escalation clause, use the change order process as an ability to either change those terms or mitigate it so that at least the change order work will get paid at a higher price. Okay? Tom, I'm going to flip it back to you.
Gotcha. So again, we're at the build phase. You're experiencing the problem of the availability and or dollars. And to circling back, something Shawn said is, if you didn't take anything away from what we said today, the key is educating the owner as soon as possible on the nature of the problem, which is why ideally you're doing this at the pre-bid phase, because then it's like you don't even have the contract yet. So, the owner, in my opinion, is more willing to listen at that phase, particularly if it's being shared as part of, on behalf of the group. I mean, if you've got a pre-bid conference and you've got a whole number of contractors in the room, as well as ideally a supplier with you, to the extent that you can then bring up then, hey, we've got a problem with availability of materials, as well as huge cost increases. And if you got a room full, there's an opportunity to say, is for the generals that are here, the subs that are here, the suppliers here, are we all in agreement on that? Okay. So, that can give greater momentum to the notion of trying to get something equitably done by way of the owner going forward, whether it be at the pre-bid, the bid phase, or otherwise during the build phase. But again, if we find ourselves addressing this problem during the build phase, again, the first thing that you're going to want to do with this or anything else, such as a differing site condition, if you encounter those, is what does the contract say? If you understand it, review it. That's the time to really, take advantage of a lawyer that's familiar with doing public construction, like Shawn and myself. What's important to recognize is something Shawn said at the earlier, which is if you're doing a federal project, the good news is there's clauses that are in there already with regard to this. And I think that's important to recognize too, in support of you when you're seeking to request inclusion of such a price or materials price escalation clause at the pre-bid phase. It's important also to note, hey, look, we're just asking you to do what the federal highway is already doing, for example, on their projects. So if it makes sense to them, it should make equal sense for you. And if you got any questions, certainly talk to them. But Federal Highway saw fit to include that. We just want the same treatment here as they found to be suitable. That's on a federal level. I note, having done a lot of DOT work, you'll periodically see DOT escalation clauses for fuel. I have not. What's that?
And asphalt as well. Yeah.
Right. Yep. Again, that can also give you further support when you're asking for something. Hey, again, I'm asking you to do something that others aren't doing. Here's some examples. Again, MnDOT, Minnesota DOT, used to have one that paid for fuel. They bailed on that, and now they said they'll give you time, but not dollars. While time is great to protect your back end from LDs, it certainly doesn't cover the extra costs associated with getting that material.
And it might not help you with price increases, related to the supply chain. Who knows if in 6 months the prices aren't even higher? So time might not be your friend.
Well, I'll say also, I had another project where, again, the contract did not include an obligation for the owner to pay for it, but we again arranged a meeting with the owner and explained, when the contractor's having problems getting it. Hey, look at, as of right now, I'm not going to be able to get it until, many, many months downstream, except that if we paid more for it, I could get it now. And the owner saw the value in terms of having the project completed earlier to pay more for it, though it wasn't legally obligated or contractually obligated, rather than grant the time extension that the contractor had a right to in order to get the project done earlier. Again, there was no obligation, nonetheless asked for it, and the owner saw the pragmatic reason to pay for it. And while the owner paid more, they got the project done sooner. What's interesting, and while I haven't seen it raised yet, your right to extra time, typically revolves around the notion that the issue that's arisen was unforeseeable. And, just sort of an FYI, is you might run into a situation where, like I've seen happen with COVID, since everybody knows about it right now, it cannot be treated as a basis for additional time because it's no longer unforeseeable. Just be aware that the owner might raise that as a defense.
Unless you put it specifically in your contract, which would be great. But another thing on time, just to add to that, while I'm looking at this AIA contract and that provision, there's often in these contracts no damage for delay clauses, right? But in that situation, it says your only remedy is time. So if you ask for time and get denied time, now you're in actually a pretty good position, because now you can get compensation. Because again, they're saying you're going to waive compensation for the additional time. I guess the theory being that you can demobilize and save on all your costs, which is not a very practical answer in the real world. But nonetheless, you got to play the contract terms as they're written. If I say your only remedy for anything is time, you ask for time and it gets denied, guess what I'm coming back for? I'm coming back for money. So I think this is your slide. It's just, you're just referencing another AIA 201.
Yeah. And before I do that, I want to follow up with an important point you just made, Shawn, which is whether it be because of material delivery delays or otherwise, the critical thing is to follow what the contract says procedurally, give notice of it right away, and request a time extension. And as Shawn said, if you're not granted that time extension and you incur the extra costs now that you otherwise wouldn't have incurred, you have a right to get paid for that under the theory of constructive acceleration. So right. I had just to go off course a second, but just somewhat, I had a project where death taxes and late utility relocation. Well, we had the late utility relocation. The contractor called me, said, "Hey, do I have a right to get dollars for it?" I looked at the contract. I said, "Nope, you just have a right to get time." Made the request for time. The county engineer denied the request. And then we gave notice as a follow-up. Okay, we're going to have to incur extra costs to meet the schedule that should be extended. And the contractor ended up incurring just, I think 1.7 to accelerate the project. And in arbitration, we got about 1.4 of that. So again, it's critical on any issue that you have that's going to potentially delay your work to make sure you're asking for time. And if it's not granted, recognizing that if and to the extent you have to incur extra costs, you have a right to get paid for it. But again, key is give notice right away.
Yeah. So some other key notice is always an important provision in your contract. Some of the other ones that you have to be aware of for this issue are on your screen right now. It's not just the material escalation clause, although that's up there, but also liquidated damages. You can put in there what you don't get liquidated damages for, right? Could be anything related to the pandemic. If COVID is now anticipated and not unforeseen, you can write into your contract, oh, but no liquidated damages for COVID or supply chain disruptions. So have it do what it says. And warranties or guarantee of performance. If you're on, like, I was just negotiating a contract with a wastewater treatment plant where the owner was selecting all the equipment, but had performance guarantees on how clean the water was going to be. And we said no to the utility. We said, wait a minute, you're going to pick the equipment that's going to clean the water, but I'm going to guarantee you certain levels of cleanliness. It's the equipment that's cleaning it. So no. But also performance guarantees related to supply chain. If you can't get something and you're going to go to an alternative, it's not really an or equal. It's equal because it's available. But just because it's available, are you also guaranteeing performance levels of performance? Think about that, because that could put you in a bad place. Force majeure, I want to quickly talk to you about that, in that it usually, as we've referenced, gives you time, not money. Your standard force majeure clause is all about defining these events of God that give you time and not money. Money may not be it. Look out for clauses for suspension of services. A lot of prompt pay acts allow, again, if you're not being paid to suspend service, what's your contract say about suspension of service? If something gets delayed and the owner says, here's a stop work order, go home, are they going to pick it up 6-7 months from now? Are you at the same wage rates? Did people get increases? Are you union, non-union? Is that increasing? When does suspension allow you to terminate? To say, listen, you suspended it for 6 months. I'm never coming back. I've filled in all my work with other work, and now I don't have the availability to come back. What's your contract say on that? Supply chain can push you into a situation where you're off the project, but it's like a sort of Damocles. It's out there. It can come back. Tom touched upon this on public jobs, contingency funds. When you educate the owner and let them know that these are possibilities, let them set aside a piece of money that is there to protect the owner and the contractor so that they have those funds to keep pushing the project through. And then the last one that is very important, but rarely thought of in the context of material cost escalation is your venue and choice of law. Why? Because not all states treat these clauses the same. Not all states treat these legal theories the same. And you can literally pick, especially if you're working in multiple states, you don't have to pick the state you work in as the law of the state that's going to control your case. So if I have a contractor that works in Pennsylvania and New York, I can say the law of Pennsylvania is going to apply even if the project's in New York. And I do that at times when there are concerns of my client over certain provisions, and I know Pennsylvania has better law than New York. So that's something to think about. You've got to have in there an ability to pick the right choice of law, which means your team has to include somebody who can guide you on that. So let me, if I can. Oh, I don't. What did I do? Sorry, having difficulty. This is the next slide. All right, so here's the next question for you guys. If you have a lump sum contract without a clause that specifically allows for an increase to the price because of COVID or supply chain issues, can you obtain an increase in your contract price? So you have no clause in it. All right. I'll give it a minute. All right. So we got about 30% of the group saying no and 72% of it saying yes. You can get additional money without having a clause in there. It's not easy. It is not easy. Part of our hope here is to impart to you guys ways to do that. So if your contract didn't have a clause in there for escalation, you're going to try to argue impossibility of performance, impracticality of performance, frustration of purpose, or if just a material supplier or vendor, you're going to use the UCC. They all to me kind of collapse. The issue here is proving that there's some supervening event made the performance impossible or impractical, meaning it's financially burdensome on you. This event has to not be anything that you assume could have happened under the contract. It's got to be unforeseen. It can't be something that you thought about, contemplated, and took a business risk on. It can't be your fault. You can't cause the fault, right? So if you cause a delay to the project and you go into a different time period of performance and now everything's more costly, that's not going to work. It can't be your fault. And the contractor cannot have assumed the risk in any other way in his contract. So catch-all phrases saying, you're familiar with the site, you're familiar with this, you're familiar with that, and you're taking all the risk. Those are going to be bad phrases for you. You can't assume it, all right? You're going to have to show more than the costs have become greater than you originally anticipated. It's got to be something unforeseen, unknown, and really drives a impossibility of performance or financially impractical for you to perform, where it could almost be ruinous to your company. One of the things that courts will consider in the federal realm and in certain states is the size of your business. By the way, if you're a small business or you're an MBE or WBE, these are factors to be considered. So you've got to paint the narrative that most protects the company. Very nuanced, very fact specific if you don't have a contract provision. So you would want documentation, detailed documentation from the beginning to the end. I mean, project meeting minutes, I mean, emails, I mean, letters, all the way through the project itself. Tom, what are your thoughts on that?
Yeah. I mean, on a high level, is the importance of really examining, what are the scope of my rights and what are the corresponding obligations? Because I can say, for me, so often when I'm involved, I'm having to spend so much more time trying to overcome or deal with, lack of written notice, late written notice, for example. Just, for whatever reason, contractors, in my experience, aren't good at either knowing what the procedure requirements are, or otherwise, if they know, exercise them on a timely basis. And what I find now is it's a very different market, publicly speaking, on a public level than it was years ago. Owners, engineers are going to look for a way not to treat you equitably and fair, but to avoid having to pay for costs if they can. And that typically will start and end with, is there a procedural defense? Okay. I want to say one thing before we turn to equitable legal remedies. We've been talking about, remedies that are contractually based. Three things. One, if and to the extent the owner delays the work into a period of time where the reason it's more costly, or the reason it's more costly to a certain extent, the owner, under most contracts, absent a no damage for delay clause, should be responsible to pay for the increased material costs that are associated with the work being delayed to a later point in time. Some specs especially provide for that. I had an example out of one DOT, the spec that says, I quote, the department will pay the contractor for increased material costs or material shortage costs due to owner caused delay. I noted when I was looking at the memo that was circulated just last month by the Texas DOT, they recognize that if they cause a delay, that they should have to pay for it, even if it's not expressly provided in their specs. Second comment I wanted to make as it relates to this is, if and to the extent you've got a material overrun, the typical, certainly in DOT specs, they have, your right to material increase, when you cross that threshold, whether it be 125% of the planned quantity. Recognize that to the extent that you've got an overrun, you've got the basis for that amount above that threshold to seek payment for the additional costs associated with materials. So even if that material cost was known prior to the overrun, you have a right to request it. And indeed, I found it notable that in fact, the DOT was said right in their memo last month. They said, and I quote, when the department finds it necessary to increase quantities of a material that has experienced a significant price increase, the department should strongly consider paying the increased material costs. So again, I think it's important to also recognize that, at least a lot of owners have been educated on the nature of this problem and are also open to dealing more fairly with you. But again, so many public owners, certainly more likely with city and county owners, are not going to be as educated. That really emphasizes the need for you as contractors and suppliers to educate them on the importance of or the scope of the problem and fair ways to address it.
All right, we got 5 minutes, Tom. We're going to keep it under an hour here for these people.
One last thing is recognize that there are equitable remedies that have been established by some courts that say if the price increases are so great, you might have a right to have your work performance excused. And we cited some courts have recognized that right, others have not.
All right. So let me ask you guys a few more questions here. We'll see how well we've educated this group. Should you seek the assistance from material suppliers and vendors to get the owner to increase the price? Who thinks that's a good idea? We're thinking outside the box. We told you to think outside the box. This is pretty outside the box. This is the guy or person telling you your prices went up.
Glad to see that 100%.
Yeah. Let's give it a little bit more time, see if anyone else is going to chime in. Yeah, I agree. This is a fantastic idea. By the way, a material supplier or vendor might know of more projects than even we've suggested that we know about. It's another source to say, hey, the guy down the street just gave a material price increase because this very issue, he understood the issues. Let me show you. It gives you transparency because it allows you then to, show them that you're not making up for a failed bid. These are the prices that are really going to be charged to you. So I think it's a great idea to include them into your sort of negotiation. So let's go to this one. Our material price increases because of COVID and supply chain issues treated the same for purposes of holding an owner responsible for extra cost. Is there any difference there? Who thinks that that's a difference? Wow. All right. So we see that a majority of the group, well, we're evening it up. Wow, we're even. It's flipping. This is crazy. It's like watching the voting on the night of the election. Things are changing. Well, let me give you my opinion on that. I think that they're very much the same. I'd be interested to hear what you have to say, Tom, but I think they're very much the same because it's an event that's outside your control that's going to increase the cost, and therefore you're going to have to treat them the same in this way. You're going to have to identify them immediately. You're going to have to put the owner immediately on notice, and you're going to have to track those costs. And by track that cost, I mean you're going to have to associate the additional cost to the occurrence, be it COVID or be it a supply chain issues. You got to tie them directly together. In doing that, you gain the most leverage to get additional money. Tom, do you think that they're treated the same, or you think there's a little bit of a difference?
Other than if the contract expressly makes a difference, it draws a distinction, I think they should, I agree with what you've said.
That's a great answer, by the way, which is read the contract, Shawn. That's a fantastic answer. I love that answer. All right, here's the last question. Are there any insurance or bonding strategies to mitigate the risk of material cost increases? Yes, no. Insurance and bonding. All right. That's interesting. About 70-30. Yes and no. I don't think there are direct, and Tom, I'll open this up to you. My experience wouldn't say there are direct insurance. I mean, obviously you can't get insurance for your own work, right? That's a typical exclusion that would be in a general commercial liability policy and an well, not necessarily E&O, but a general commercial liability policy. But you can get insurance for a defaulting subcontractor, and you certainly can require, even if you're the prime, there's additional cost, but you could definitely push down the risk through a performance bond. And I think in that way, if you were going to look at a job and you were really concerned about, a certain area of work and the equipment necessary and material necessary for it, you could subcontract it down and get defaulting insurance for a subcontractor insurance. And in that way, protect yourself, meaning that if the subcontractor comes back and says, I'm going out of business, it's too much, I'm done, I got to go, you've got insurance for that, for the defaulting subcontractor, because it can't live to its contract. So it's sort of an out-of-the-box thought. Be honest with you, I haven't seen it in application with respect to supply chain issues, but I think that type of insurance, or again, a performance bond, if the subcontractor said, well, you've driven me out of business because you haven't given me a price increase. Now it's the surety's problem. So I think creatively those might be avenues for a bonding or insurance strategy. What are your thoughts, Tom?
Yeah, what I hear is, whether it be because of this risk or otherwise, it's prudent sometimes for a general to consider the sub bonding back. I just would say that on a general level, make sure the sub knows about it at bid time in order they can include that cost in their bid. But, whether, if you're working with a sub that you haven't worked with before, or the sub might have some issues, some concerns, one way to protect yourself is to require them to bond back.
Yeah, you'll definitely buy yourself some peace of mind. It might cost you 1% of whatever their contract value is, but that might be worth it. I recently, again, apart from supply chain, had a contractor do that when he was hiring a MWBE, and the contractor had a big contract, and it was a very small company, and they went out and they made that, and they gave it up. They couldn't get it from the owner, but they made the subcontractor go out and get a bond, performance bond, and it gave the general peace of mind on the project that, if they weren't around to finish the job, at least there was a surety that was going to back it. So definitely some things to consider. And that brings us to our conclusion. Tom, you want to handle this?
Yeah, I'll be quick. I mean, again, we all agree this is a huge problem. It's not going away anywhere anytime soon. And so we really need to be looking at, in my opinion, the whole panoply of options. And we've gone through, listed a number of them. I'm sure you'll be able to come up with more. Again, I always like I like what Wayne Gretzky, if you're older like me, one of the greatest hockey players said, I missed 100% of the shots I didn't take. And so the moral of the story is, whether it be asking for a change order or asking for inclusion of a material escalation clause or any of the other recommendations that we've made, the owner can't say yes unless you ask for it.
Jimmy?
And the last thing that two other things I want to say is, I really encourage and request that members, to the extent they have success on a project, getting any one of these or other
you hear this?
Changes made, to share that, in order that we can build on that, and it's easier for the next contractor requesting something to have that much more ammunition in support of them. My parting comment is, I was also thinking some public contracts have a termination for convenience clause that allows the contractor to exercise to terminate the contract if there's a delay associated with it. So that might be another clause that might give you leverage if that's included in your contract.
All right. Well, that's fantastic. Well, that brings us to the end of our presentation. I appreciate everyone hanging in there because we've given you, again, a lot of issue spotting, meaning there's a lot of variables. These are nuanced, factually based requests for additional money because of COVID or supply chain. Start with the contract, think about the things that we've suggested, and start to frame the best narrative to protect your company. Bob, are you there still?
Yes, I am. We've got actually two questions in the chat, and I notice a lot of people are still hanging on. So you've presented a fascinating topic for them. First question is from our board member, David Howe. This goes back to slide 14 about owners pre-purchasing material for contractors. His question is, and it's a very pertinent one, does fuel count as energy or material?
I think fuel does count as energy. But in 14, and I don't know if I could get back to it.
I wrote that one down. It
wasn't necessarily 14. It was down at the beginning when we talked about the price escalation at pre-bid and the questions, and you had in there the percentages and stuff like that, and the materials. It said materials and energy as the options for potential escalation, but I didn't see fuel called out specifically. So I was wondering if that counted as an energy, or was that counting as material, or was fuel not covered in that price escalation question for pre-bid?
Can I jump in there, Shawn, while you're looking here?
Sure. Yeah, go ahead. I'm trying to
hey, David, my view would be, if I wanted it covered and it wasn't clearly defined, normally the rule of law in public construction, if the language is ambiguous, the ambiguity construed in favor of the non-drafting party, which would be you as a contractor. So, my argument is, depending upon how I wanted it treated, if the language that was used didn't clearly answer that question, you'd certainly have that rule of law that I think is pretty much universally recognized throughout the country.
Yeah. And I'll just add to that. I gave a material escalation clause in that pre-bid section where it talked about material, equipment, or energy. And I was certainly, when I wrote that, thinking of fuel in the clause itself, but it's always better to be more specific than general. And talking about it, I probably will modify that in my contracts to make it more particular that it is relating to fuel. So if you're looking at the form of material escalation clause that we suggested for the pre-bid, I would definitely change that to fuel.
We've got another question. This one's from Robert Fassini. Does the pre-bid speaking on behalf of the group or looking for consensus, does that question come close to antitrust issues? Should the person asking the question have an antitrust lawyer present?
I'll take a shot at this first off. I don't think that anybody asking a question at a pre-bid meeting would really be in control in a vertical or horizontal way of the pricing. It's where you affect the market. So that type of analysis of having a monopolistic influence on the price has to be over the market itself, either in a horizontal or vertical manner. So certainly we wouldn't want to go out and collude with suppliers in a way that would affect the price over certain sectors of the market. But I don't think that asking any questions at a pre-bid meeting would rise to that level. And by the way, any of the answers would be published and sent out as an addendum to the bid solicitation. So I think you're fine there. I think what you're doing at the pre-bid meeting, again, this is part of the education. You're saying to the owner, hey, this might happen. And even if we can't change the contract, I may be coming back to you and asking for additional money down the road. And I want you to know that it's before I submit my bid, that it's a factor that nobody in this room can quantify at this time. We'd all be guessing. And that's not really the point of public works contracts. It's not necessarily to make contractors guess at the price. It's to put everybody on a fair and even plane. So I don't think it's monopolistic, but I'll turn it over to you for any additional input, Tom.
Yeah, I mean, I agree with Shawn, and the other point that I was just thinking about, that it was addressed in the one of the overheads or one of the slides, but we didn't get into, is if I'm at the pre-bid, whether I'm going to include a contingency in my bid or not, certainly I think to help sell the owner on including in any one of the recommended contractual changes that we made, including a price escalation clause, just say, look at, if and to the extent you're not going to, pay us for that, you put us in a position of either bearing that cost or otherwise covering ourselves by way of including a contingency in our bid. And the problem with including a contingency is the actual cost might be well below what we include as a contingency, so the owner's left paying something beyond what it should pay. And so to avoid contractors including contingencies in their bid, allow us to price it on the basis of what we know, and if it goes up, pay us for that, which is to say, treat it no differently than you would for a differing site condition clause or differing site condition. The whole reason that DSC clause was required to be added by way of the feds and all DOT projects is, if you read the cases on it, it said the feds said we don't want contractors including contingencies in their bid. So that's also further support of why a price escalation clause, for example, is appropriate. That's all I got.
All right. Well, I'd like to thank everybody for participating on this presentation. I appreciate the input, the answering of our questions, and asking us questions at the end. Again, I would end this with what Tom said earlier. When we have success, let's share those successes so that we can make it even greater.
If I can add one more point is, we have the benefit of this organization to be able to share, all sorts of technical and legal advice with each other. And to the extent that you have other issues that you would like us to address by way of a webinar, please, make that request. I mean, let's make a difference beyond this one issue. So, yeah. Right, whether it be something that calls upon lawyers like ourselves to speak, or otherwise they might be technical issues. Let's really take advantage of the knowledge that we collectively have as an organization.
Thank you very much for your time today to participate in this panel. We'd also like to thank our national partners for generously supporting NUCA and our monthly webinar series. Today's webinar has been recorded. And thank you for your time today to join us for this special webinar Wednesday and supporting NUCA. Thank you for your time this afternoon, and please enjoy the rest of your week.